Hi, everybody. I'm immigration lawyer John Khosravi. It is August 31st, 2023, last day of August. Thank you so much for joining us for our regular live Q&A to talk about U.S. immigration law, taking your questions to provide general educational content for you to learn more about it. If you like to have one-on-one kind of thing about your specific case, this is not the place, general kind of stuff. You need to have a private consultation. As a benefit for those watching the live show, we give away 3 free video consultations each show. 15-minute video consultation live in private. All you got to do is click like, subscribe, and write consultation in the description section. And my wonderful assistant Kayla will announce the winner every 10 minutes for the 30-minute show. And hopefully we'll get a chance to see each other and talk in private. I love doing that. I love getting to know you. And so we just have such a loyal and great fan base and audience here that it's always a pleasure. Having said that, if you're interested in a marriage green card, fiance visa, the first thing you should do is download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. The website is marriageimmigrationlaw.com. And through that, you get all the basics of what's going on with U.S. immigration. Now, M. Sadef says, hi, John. Hi to you too on Instagram. We're live on Facebook, TikTok, LinkedIn, YouTube. We have multiple YouTube pages, multiple Facebook pages, and Instagram, I believe I said already. So we're going to take your questions live as they come in. So let's get it started. All right, thank everyone who's joining us. It's always a lot of fun taking your questions. I may not be here next week, just a heads up, but we're here almost every week of the year for the last 2.5, almost 3 years now, and it's been a great pleasure. The U.S. immigration system, some stuff's gotten better, some stuff's gotten worse. It's still a mess. Right now, it's a catastrophe happening in Pakistan, and it's already, when it comes to immigration, just a disaster, because getting an interview scheduled in Pakistan has been horrible. People are waiting easily 2 years to have their marriage green card interview, not even other types of cases. But with the flooding that's happening, not sure what's going to happen. I got so frustrated with the embassy that I went to the Twitter page for the U.S. Embassy in Pakistan and said, hey, because they're posting all this stuff about, feeling bad about what's going on and support for the people being flooded in Pakistan. And I said, if you want to support them, please interview these people so they could leave. They are married, their spouse in the United States, they're waiting to go. A year has gone by, 2 years gone by, still no interview, and now they're getting hit by a flood. So I said, do us a favor and actually interview people. That may be the best way you can help. It's the only way you can really help. And so let's do it. So that's something that's happening. Now, let's take a couple of questions that popped up. We have a user on LinkedIn says, hello to you too. And YH asks, I'm a U.S. citizen and I'm planning to file the form I-130 for my parent. I'm currently outside the U.S. for almost a year and returning in a month or two. Is it okay to file the I-130 when I'm abroad, or do I have to be in the United States and living for a certain period of time before filing the application? So no, there is no requirement that you be physically in the United States when you file the form I-130 petition for alien relative. This is the form used for applying for your sibling, child, parent, or spouse. Now, when you do have to be living in the United States or very close to living, depending on the interpretation of the embassy officer, is when your parents are starting the green card process through the embassy. So what you do is, if your parents are not living in the United States or outside the United States, you file for I-130. Once that's approved, you start dealing with the Department of State. The first agency is the National Visa Center. Once they review your initial documents, they move it to the embassy. By the time your parents go for the embassy interview, they want you to be living in the United States, or domicile is a term they use for that. So that's when it becomes something you got to think about. Now, if you're already living, attention there if you're living or not, because you in your forms you're in your U.S. address. But if the I-130 you have a foreign address, they're going to be much more like paying attention to say where you're living now. Because of that, if you are for certain going to move to the United States, you want to have job and proof of employment and housing, all this kind of stuff. So later on, when the embassy step starts, you could tell them that, hey, I am living here. Here's proof, and they'll satisfy the domicile requirement. But things are so delayed everywhere. If you know you're going to be coming to live in the United States just in a month or two, I would run with it and file a case. In general, again, I can't give individual legal guidance because I don't know enough about you to say whether you should file or not. There might be some issues I'm not aware about. But generally, I don't hesitate in this scenario based on you not living here. That's not a factor that comes into my consideration. If you are going to be moving really quickly into the United States, it's just a month or two. Generally, I say get started. But again, I don't know your individual case, so I can't comment on that. Next question, Jay asks, hi, I'm filing adjustment of status based on marriage to U.S. citizen. My spouse currently doesn't meet the income requirement for sponsorship. I have OPT EAD, recently graduated, started working 3 months ago. I'm able to meet the income requirement. Will I be able to use the income for Form I-864? So when you're applying for a green card, there's a requirement that you show the ability for the U.S. person who's sponsoring you to make enough income. However, if they're not able to make enough income, they could use a household member's income or a joint sponsor, and other parties do it, or even assets. But let's stick with income in this particular scenario where it's the spouse making income. So, or the attending immigrant making income. The rules are that the person whose income is going to be used, in this case, the foreign national who's already working, as one, if they're working in the United States, work is lawful. So you could be, here without status, and you're working, making $1 million a year. You can't count that money. It's not being earned lawfully. You are earning it lawfully with your employment authorization document. And secondly, they have to show this income is continuous. And it's going to continue after getting the green card. So based on that, it would seem that it would be okay for you to get your income in based on the OPT. It means you're a student, you graduated, you're working for somebody for a period of 1 year lawfully in the United States because you have F1 OPT EADs. For those who don't know, initials, essentially, it's a work permit people get when they graduate college for a year. However, I wouldn't be comfortable in filing it because although you kind of meet the basic requirements of the rule, it's going to be up to the interpretation of the government whether they're going to accept that as discretion. Because first of all, that money's new. You just started making it or going to school beforehand. They may not trust that money will continue. And secondly, they just might not buy into it that this is a consistent job that's going to be there past the OPT period. Although I'm certain that this is going to continue to make you more money, I would not be comfortable in filing it based on your own OPT because they might come back and push back. It could be approved. I'm not saying I'm not guaranteed 100%, but because I would worry about it in this kind of case, I wouldn't want to get a joint sponsor. If you have enough assets, use the assets. I'd prefer not to use your income. I wouldn't be comfortable using your OPT income because of the discretionary power that they have in these kind of cases. It's just too risky. You don't want to file something, have it denied, and waste your time. So I would be looking for a joint sponsor probably in this kind of case. But thank you for your question, Jay. Aylin says, waiting to hear from USCIS for 12 months in the U.S., married U.S. citizen, but only received notice of action for number one for form. Immigration lawyers don't call it notice of action. We just call it the receipt, the fingerprinting notice. We use casual language. So we get there's a lot of emails. People say, I got form I-797 or notice of action. I know the forms, the self-help forms, they call it NOA1, this and that, but immigration lawyers don't call it. We just use regular names. No other notices, no biometrics, yes, normal. If you've been in the U.S. and you file for adjustment of status and you have not received biometrics appointments or a notice of a waiver of the biometrics, that is abnormal. I don't know enough about your case, Aylin, but different offices had different timelines. During COVID, the biometrics appointments were pushed back, but right now, biometric appointments are happening pretty fast. So if you're a married U.S. citizen, you receive one notice on one form, that's an issue. Maybe they didn't get the other form. So you might have filed the form I-130 combo with an I-485, adjustment of status, and the work permit, affidavit of support, child permission and work permit. But if you have one notice, you probably just got the I-130, which does not have a biometrics requirement. The adjustment of status does with the EAD. So maybe the other forms didn't go in properly. I don't know. You got to see whether the check was cashed or the credit card was cashed to see if those were. You should have received notices. And this is a big role of an attorney if you had an attorney in this case, because the lawyer also gets a copy of all these documents and they're able to, check this stuff and be aware if there's something missing and the like and keep an eye on it. But yeah, if you only got one receipt notice, I'm guessing what you mean, but you have a whole adjustment case, there's a major issue there. You should have got biometrics. So if something is lost, you really need to look into it. Like 9 months ago, frankly, after like 1 to 3 months, it should have been gone into. But better late than never. But I hope you're able to figure that out. Sorry that you're going through that. Hagandaz says, would gay marriage work for U.S. citizenship? I don't understand what the question is. It doesn't. I think you mean if you get married and you're in a same-sex relationship, can you apply for a green card, which after several years becomes citizenship? Yes, it's possible. It's just like any type of marriage for the United States. Imran asks, I applied marriage-based green card application in May 2022. My spouse is a U.S. citizen. My application was received by the National Benefits Center. My fingerprints are waived. My RFU was received. I don't see the question there. I'd say, is there any approximate time once you submit the papers? No, there's no approximate times. You just got to wait. There's no real timelines for U.S. immigration, unfortunately. Renta Bruva asks, I've applied for my I-130 in process for my husband, but the process is taking so long that he wants to come to finish college here. Can we apply for the F1 visa? Yeah, you can apply. Most likely it's going to get denied, but you could always apply. Who knows? Because when you apply for F1 student visa, you're saying I'm coming to the United States for temporary purposes. I'm not going to file for adjustment of status and apply for green card in the United States and stay there. So because of that, knowing that you're married, knowing that you're I-130 depending, they're probably going to deny it when he goes to the interview. But if you really want to do that, give it a shot. You can tell the embassy officer, hey, listen, I'm not going to file for adjustment of status. Once my I-130 is ready, I'm going to leave the United States, do consular processing, come back, and they may be down with it. Very low likelihood, but if you really want to do it, it's wasting time and money, but it's not impossible. It's something that's maybe possible. It depends on the officer. Again, very unlikely. If someone's going to hire me to do that, I'd have them sign something that says I've told them that this is highly unlikely. So it doesn't look like I fooled them into doing something like this. But if you really want to give it a shot, then go ahead. All right. LinkedIn users, excellent info. Great job, John. Thank you so much. Unfortunately, the software doesn't tell me who the users are on LinkedIn, but I really appreciate it. It just says LinkedIn user for me. But I have great people on LinkedIn. I love using that platform for getting the word out about U.S. immigration. Rose Marie asks, my category F2B priority. Oh, sorry. You know what? Really quick. I'd have to announce our winner for the free consultation. Jay Ram, Jay Ram, thank you so much for watching. What I want you to do is take a screenshot of where you're watching this and email it to me at info@jqqlaw.com. In the screenshot, I want to see like your username in the corner, wherever app you're using, so I know it's really you and not some other person. Email that to me at info@jqqlaw.com, and I'll respond with instructions for scheduling a free video consultation. For those just tuning into the live program, we give away free consultations. I think we have, how many people do we have? We have like 30 people on the show right now. We give away free video consultations. All you got to do is like and subscribe wherever you're watching this and write consultation in the area where you comment. And my wonderful assistant will name 2 more people, one in 10 minutes or 7 minutes and one in 20 minutes or 17, just because we're a little late. And you could get the free video consultation. And if you're interested in a marriage case, a fiance case, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And now let's go back to the question Manny was asking. My category is F2B. That's an adult child of a green card holder, unmarried adult child. What is the wait time? 7 years from Jamaica. Check out what's called the Visa Bulletin. If you go to Google, type in Visa Bulletin, and then go to the Department of State website that has it. Look for the most recent month's Visa Bulletin. You can click on that. For example, it's August. Click on August or September. And the first chart that comes up, look up the F2B category in the first column. And that's the year of cases. That's the priority dates, when other people's cases are filed that they're issuing green cards for right now. If that date is past your date, then you're good. You get it done. If it hasn't reached your date yet, then you got to wait a little bit longer for your case to be able to get an interview and to be. So that's the explanation. I'd rather teach a person a fish than give them a fish. That'll help you constantly check on your own, so you'd be aware of what's going on there. Why falls up? I-130 form asks for addresses where I live in the past 5 years. Shall I also provide my temporary address or broad address? Provide my U.S. address. Now, this is asking for case-specific guidance on how do you fill out a form. Because I'm not the attorney on this case, I'm not the preparer. I can't give exact guidance other than be honest, tell the truth, whatever the facts are. You got to put that there. But this is too case-specific. I can't guide someone how to fill out a form without being the official preparer of the case. You say Makeup Studio says, how long are work permits taking to come if you apply for adjustment of status in May? So, last November, they got really fast. It was taking 4 to 6 weeks, and we were really happy. And all the spring was like this. And this summer rolled around, and now I have several cases that are 5, 6, 7 months still with no work permits. So how long is it going to take? Maybe 5 weeks, maybe 5 months, maybe longer. Unfortunately, it's not a consistent system. It's very disappointing that USCIS was not able to keep up with the promise they had made and the changes they had made to get these work permits out in a reasonable time. It's gone back to the old days, unfortunately. Man, yes, my wife is traveling with the IR1 visa. Can she enter any airport or have to be the same state? Now, when you're entering the United States, after doing your green card interview at the embassy and getting an immigrant visa, whichever category it is, you could enter the United States at any airport, and that's where they'll process your case and finish it. Just as very important to pay the green card fee before flying into the United States and doing it afterwards. So that $220 or $225 fee you have to pay pay it before entering, but it doesn't matter which airport, as long as the U.S. airport to enter, it doesn't have to be in the same state. That's all good. Si Bosorio asks, can someone who was deported and returned qualify for parole in place? Probably not, because you're probably subject to what's called the permanent bar, and the permanent bar is a major thing. You have to wait outside for 10 full years. So can you apply for parole in place? I'm not sure. Maybe you could apply for it and still get the benefit, but you can't adjust status. So that the reason why you usually do parole in place is adjust status. I haven't done the situation. If you're here illegally, essentially without permission, if you file for parole in place, you're going to tell the government, hey, I live over here, and you're subject to a permanent bar. So there are consequences for making that request, and you got to ask yourself, how beneficial is it for me to get 1 year work permit, but I can't adjust status, for example, if you're married to a U.S. citizen, you're a parent of a U.S. citizen, because you're subject to the permanent bar. So I never really got into reading the rules on if you could technically get PIP in this kind of situation, because in the big picture, it's a worthless endeavor. So if you want to know more about your case, you got to schedule a private consultation with an attorney. But that's the real strategy and logic behind just the whole idea of what you're doing. Malik asks, how long does a green card marriage interview take after you submit all the paperwork to the immigration office? That's up to the officer as dealing. No approximation of time. Next question is El Myroon asks, can I sue the immigration department since my interview December 2021? Still no decision. They still keep reviewing. Yeah, you can do whatever you want. You can always sue. It just depends on your case and facts, and if you want to spend the money, and if it's worth it. There might be major issues with your case that you don't want to push the issue, but it's up to you if you want to sue. Talk with an attorney in private. Chilin Lemons asks, what happens if we move to another address after sending documents for green card application? We have to update the government with the change in address with form AR11, online form AR-11. And what happens, we'll send the documents to the new field office if you left the local area. And that could trigger issues of things being lost in the mail, your file being misplaced, all that kind of practical kind of stuff. But at the end of the day, do what you got to do. If you got to move, you got to move. So it is what it is. Mr. Tusk asks, I'm about to get a divorce and have tons of evidence to prove my marriage. What is the rate of success for removal conditions alone solo? That's not a wise way to look at it. Every case is different, so you can't compare your cases, removal conditions based on a waiver with another person's. You just look at your own case and say, do I have evidence? Am I prepared to talk about it? Do I have good explanations of documents? And then you go by that. Rate of success, if you're talking about my firm, I've always been successful in these cases. But again, whether it's me doing it or the whole world, it's not something to compare. Everyone's case is different, so it's not something that's comparable in my opinion. Manny follows up. My wife is. We already answered that question. Aliyah asks, absolutely refreshing working with John. Really knowledgeable duo. Thank you, Ali. Appreciate it. I mean, you said Yahya. It's been a pleasure. I look forward to getting to know you better through this process. God bless you. Majid asks, how Canadian citizens move to USA to get a green card? So if you're a Canadian citizen, it's the same as everywhere else. The only benefits of being Canadian are you could get what's called the TN NAFTA TN visa, which is to be able to come to the United States very quickly and get a work permit if you have a job lined up in certain categories related to education or experience. But other than that, it's pretty much the same old for everyone else. There's family-based options, there's asylum, which is probably not going to work from Canada, and employee-based options and investment-based options. It really depends on your background and what you want to do. That's a general overview, but most of the time, people have to have jobs lined up and the employer files for them, or they're very wealthy investors if they want to get a green card, or they get married. Most of my Canadian cases are people either getting married, or they're here, they're top people in their field, the extraordinary ability green cards, or their employer files for them, and that's like that. Alien follows up. I talked to USCIS, but they keep saying they will call back. They cash the checks for I-130 and I-45, but only received a receipt for I-130. How can I check the case is processing normally? Well, you need to go and complain on the website that you did not receive the receipts for Form I-45, I-131, I-765 if you submitted those additional documents. There's a place for getting notices on that. Also, if you got the I-130 receipt, usually the I-45 receipt is one number less than the I-130, so that'd be a way to see what's going on there. But you got to follow up with that because you may have received an RFE on your I-45 and it gets denied because you're not getting it. Maybe you put down the wrong address on there. Maybe the apartment number wasn't correct. There's just a lot going on. There seems like some sort of mess up happening with your case, either because of what you did or because the government did, or that stuff happens on both directions. Even if you have lawyers, the mess ups happen. But you just I don't know. It's just too case specific. I got to go deep. I got to review your form, see what's going on. You got to go in and complain that you didn't get it. You got to keep calling him, get the congressional representative. You got to just get into it and defend your rights. That's what attorney's role is and all that stuff to help you defend your rights. To ask, what happens if we move to another address? As I said, I explained that one already. I prefer people don't do it because it messes things up a little bit because things get lost. But at the end of the day, if you got to move, you got to move. 29 Super C, good regular. Good night, Attorney Castrov. Just checking in and hope you're doing well. Enjoy your Labor Day weekend. Thank you so much. God bless you. 29 Super C, one of our regulars who went through the process successfully. Great seeing you and talking with you again. 29 Super C. I want to announce our winner of the second winner of 3 winners today for the free video consultation. Syvosorios, Syvosorio. Thank you so much for watching. You won. Take a screenshot of where you're watching this and email it to me at info@jqqlaw.com. I know your username is yours. And yeah, we'll schedule a free video consultation. For those just tuning in, we give away free consultations. We have one more left. Gonna name a person in 8 minutes who likes and subscribes and writes consultation in the description or comment section of where they're watching this. And my wonderful assistant, Kayla, will name someone behind the scenes to me, and they'll get a winning. Also, if you're interested in a marriage or fiance case, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. It's the best guide for you to get to know what's going on in the process before you even start, before you talk with a lawyer. Learn and educate yourself. Great resource, 40+ pages. You're going to be really surprised at how much in-depth information is in there just for free. Most of the time we download these guides, they're 1 or 2 pages, and they're a trick marketing thing that says contact us. Down mine, you're like, I can't believe this person's giving away the secret. So go download it at marriageimmigrationlaw.com. Okay, son of Abdi asks, I live in Turkey and my father is a U.S. citizen. He wants to bring me to the U.S. I'm over 21 years old. Is it possible for my father to petition for me? How many years does it take? Yeah, your father can petition as the F1 preference category. If you're not, you got to first see if you're already a U.S. citizen or not. But if you're not, it's probably going to take 9 or 10 years or something like that. It's the F1 preference category. You got to check that one out. We have some questions right here on Instagram. I want to jump in really quick. Let's see. Simron asks, how can he see the movie? Okay, we already answered that. How can we protest against delays or not to prove? You contact your congressperson, but no one cares. Immigrants don't get any attention or care by the U.S. government, so there's nothing you can do. You can file lawsuits. That riles them up because it causes them to work. So if you really want to complain, you put the money in filing a lawsuit. Really, that's the only way to complain. But let's say the next question. James asks, hi, I'm a U.S. citizen. I want to petition for my son. Filing online or sending all files via mail. That's up to you. As an attorney, and most immigration attorneys file things by paper. But most of the time when people do it pro se on their own, they do it by online filing. I avoid at all costs doing things through the computer with them because I don't have faith in their systems operating properly. So I like to have everything submitted to my paper, but it's your personal decision. And I guess I answered that question as well, the follow-up question. Notorious asks, is border crossing card proof of legal entry for adjustment of status? Well, okay, let's talk about this. If you're from Mexico, because the Mexican population is come and go so much in the United States, they created a tourist visa called the border crossing card, which says with the card, if you come in by car or walking into the United States, you could come in with that card up to 20 miles or 50 miles or something, depending on which state you're coming in and go. Because a lot of times people in Mexico come shop in the United States, get some gas in the United States and go back. So they wanted to make it easy for them. Usually if you enter the United States, they issue what's called a Form I-94, which is a record of entry. But because when you're entering at a land border, there's so many people coming, they don't always do it. They usually don't do it, especially for a border crossing guard. If you flew into the United States, your border crossing card becomes just a typical B2 visa, and they will create an online I-94 re-entry. But let's assume that you entered by land, so there's no I-94 admission, so there's no online proof that you entered. There may be in your travel history on the CBP website there. But and you probably didn't get a stamp your passport because, again, at the border, they're so busy, they don't typically stamp all the passports. On its face, yeah, border crossing card, according to USCIS policy manual, is evidence that you enter lawfully because you had a visa. Why would you? So it is. I prefer not to use it. I try to find evidence of you coming or letters and affidavits as backup, but it can be used as legal as evidence of legal entry. And USCIS policy manual says it as well. And it technically should work, but I'm hesitant because government's the government. They're unreliable. There's discretion. So I'd want to know the whole facts. But on its face, the policy manual says that that could be proof of lawful entry. Secondary proof. That's major evidence. Because the reality is, why would you sneak your way in and come in without permission? when you have a document that says you can come in with permission, it doesn't make sense why you'd sneak in. So it is permitted use, but again, I would need to see your whole case, see how I feel about the whole situation before I'll tell you to do something like that. Amora asks, hi, Mr. John. I'm in the employment history section. Should I mention only the employment history or even the unemployment period or just the jobs? I typically just do the jobs. My associate was reviewing the forms, and she's like, well, this form asks for unemployment, stuff like that. It depends on which application you're talking about. For Form N400, I do for naturalization. For I-130 and stuff, only if you're currently unemployed do I list it as unemployed. But I remember, it hasn't practically mattered in the past, so take it as you will. But my associate just a month or two ago was mentioning this, like, should we start putting unemployment? But it just creates more paper and more, like, it just makes it more complicated for the officer to review the case, because especially for something that doesn't matter. So it's up to you. You should read the instructions. I can't provide guidance on how to prepare a case yourself, but just read the instructions as they're and stick with that. So the best advice I can give. Sarah asks, are K1 visas really taking 13.5 months? How much longer after that will fiance be able to come in here? I'm also Moroccan. Is there bias against North Africans, USCI? So there's a couple of different questions there. Are K1 visas taking? So there's a K1 is a fiance visa. If you're a U.S. citizen engaged to a foreign person that try to get your fiance here. The first part is filing Form I-129F. That takes anywhere from 6 to 8 months to 13 to 15 months, unfortunately. It's random how long it takes. Once that's approved, you have to wait for the embassy to work with the embassy to schedule an interview. Some embassies are not scheduling interviews. You might have to wait 1 or 2 years to get an embassy interview there. So how long is it going to take? Who knows? 1, 2 years, 3 years. I've seen all those 3 options happen. With regards to bias against North Africans, maybe it sometimes is, sometimes isn't. It's not something that's 100%, but I do see some stuff that sometimes like, what's going on? But that's that. All right, we got 1 or 2 more questions before we go. Lawrence Nicholas says, it's 12 months since I filed my I-130. No updates yet. Yeah, unfortunately, I-130s are backing up again. They're getting 6 to 8 months. Now they're 8 to 10 months. And now they're getting close to 12 months plus for getting adjudicated, unfortunately. And MD asks, EB3 unskilled green card approved. How long have to work with my employer who is sponsored? I have a lot of videos on this. Go to our JKK Clips channel where I've talked about this. The reason why I have to cut it off is about to end the show right now. But go to the JQK Clips channel about my interpretation of this. At the end of the day, there's no requirement that it's not slavery. You don't have to keep working with them. But it depends on the facts, because we don't want U.S. guys to think later on when you file for citizenship that this was a fake job, and as soon as you got a job, you quit. It depends on all the facts of what was going on. For example, if you've been working with them for 10 years and you get paid, $50,000, and you finally got the green card through them, and some other person says we're going to pay you $150,000, to me, that's a good reason to quit. But I have colleagues that say, no matter what, wait 6 months, no matter what, wait 12 months. At the end of the day, you're not a slave. You can do whatever you want to do. But I would need to talk with you and learn about your personal situation, the facts of everything, before I would give individual guidance. So I want to announce our winner, then take 1 more question. Amar L, thank you so much for watching. Take a screenshot of this and email it to me so I can see your username. That is you to info@jqqlaw.com. That's my email. And from there, we can schedule a private video consultation to talk about your case. So they're just tuning in. We do give a free video consultation on the live show. We're out for today, but not next week. I'm probably not going to be here next week, but the week after that, Wednesday, 6 p.m. Pacific. Tune in and watch the show, and we'll try to get you a free video consultation there. Having said all that, let's take 1 more question. Hopefully it's a good one. Amanda asks, my mother naturalized, children were under 18 green card holders, but was studying in Brazil at the time. The physical presence can be proved just with divorce paper giving full custody to the mother. That's an issue because I haven't had this issue pop up. So you do, let's see, the rule is that if you're a green card holder, and your parent naturalized under 18, you become a citizen as well. I haven't dived into the custody stuff, because usually parents, children, the mother has to be in the United States to be able to get citizenship. So they're residing here. Usually their kids are there. I haven't dealt with the scenario. It's something I have to research. So, a regular consultation is needed because I got to research. But ask around. Unfortunately, I don't want to give an answer to that because I just haven't dealt with that scenario before. I'd have to read the instructions and regulations and details to answer that, which I can't do here. We have to schedule a formal consultation with the office for that, Amanda. But thank you for your question. Sorry, I don't have one answer at the top of my head. And then let's get 1 more just to make up for that. Alan asks, can a Canadian with an ongoing F1 petition work on TN? No, you got to choose. So if you're a student, you're a student. If you're working on TN, you're a TN. That's that. Let's get another question. We'll go a little bit deeper before we end. AJ asks, do I need to take a spouse's citizenship interview after 5 years green card? No, you don't. After 5-year green cards, go by yourself. Let's jump into Aileen because she's following up. How can we get congressional? Okay, so Aileen says, how can we get the Congress representative help in a case where inquiries have in place and still USCIS does not respond? I've only received one receipt notice. How do we contact? You go to the website of your congressional representative, and there's a request for help with the federal agency, and you put it in touch with them. And that's that. Now, I would use the option on the online system, USCIS.gov again, to see, say the case receipt never arrived, and try to get it. But that's how you do it. Contact Congressperson, explain the situation, it's a mess, and take it from there. Thank you so much for everybody who is watching the show. God bless you. Unfortunately, we're done for today. I probably won't be here next Wednesday, but we'll be here after that. Take your questions live. I love being here talking with you stuff. A lot of great questions. I was stumped by one of them, so it's great. And just got to keep researching. When it comes to immigration law, there's just so many little things and scenarios because people's lives are so different that it just breaks down to 1,000 different ways something can happen. And so you always got to go back to the regulations, to the statute, to case law, and study this stuff, and then add to that experience of colleagues who may have dealt with it, because even if the rules say one thing, it doesn't mean the government's actually going to follow the rules. So we got to analyze and all see how it's worked in the past and take it from there. I guess that's it, everyone. God bless. Be safe. See you soon. Bye-bye.